30 calendar, except for the one case we've passed, going to our 1400 PUNTA traffic 30 calendar, except for the one case we've passed, going to our 1400 PUNTA traffic calendar at number 1 for Philip Dickel.
Mr. Bickle, come forward, please. We're here on a motion that the defendant filed. You also have a motion on here for some discovery, apparently. Were you able to purchase the CD that you requested?
I have not purchased that. I was actually contemplating going above for a writ of mandamus, as the language of the law indicates, contrary to what was conveyed to me.
All right. Well, do you want to do that before we hear the motion? You're going to do it. It may make some difference on how the motion's perceived or evidence you have. I don't know.
It shouldn't. I would like an entire record, but the last time I was here, you had rescheduled things for today because there wasn't any time for things. I just wanted a complete record. That's all. I don't believe that it will have any effect on the motions.
Okay. Well, I've read your motion and the opposition provided for by the state. Is there anything further or anything else that you need to add other than what's in your motion? You've pretty extensive, quite frankly.
Yes, the prosecution actually completely failed to address the issue of valid service of process, and in my brief, that was laid out in paragraph 8 and paragraph 9, paragraph 11, and 13 in particular. I mean, it shouldn't be a issue of clarity for them. It's spelled out. I included the judicial notice number 3, which has the self-authenticating piece of evidence for the Hawaii Revised Penal Procedure, Rule 9, which lays out the actual process for obtaining the appearance of a defendant. And again, the prosecution in their response has absolutely nothing commenting on this whatsoever. And as it should be well known, to establish the jurisdiction of the court, you need the subject matter jurisdiction to be proper for the court, the scope, which it would be in this case if somebody authorized to represent the people of the state of Hawaii had filed a complaint. And that's a separate issue I'd like to come back to. But that particular thing would then need to be served on me, which it wasn't, and they make no indication that they attempted to. And I've included those 2 letters. The one was dated December 9th. That was the second letter to them. And the other was dated November 28th. And both of them inquired as to whether or not they were going to initiate prosecution, and if so, who were the prosecuting attorneys so that I could communicate with them on the matter. And the letters, are you familiar with them? Is that something you can recall right now, or should I
No, I have the
discuss that?
I have the documents that you filed with the court. I don't have any correspondence between yourself and the prosecuting attorney.
All right. Well, that should have been attached to the back of the motion to dismiss for lack of all jurisdiction. I have a copy here I can let you look at. It's a certified copy by the court clerk. Would you like to take a look at that? I'll need this back, though, because I thought you guys had all of that since I filed it.
Hang on a minute.
Okay. The very first letter would be found after page 10, where I verified the motion to dismiss.
I have letters here, yes, thank you.
Okay. All right, so again, in those letters, I actually explicitly indicated that I wanted to know if they were going to initiate prosecution and who to communicate with regarding requests for discovery material, if not them. And I offered some presumptions, which I told them, you know, if they're busy and they can't respond, please just correct me. Let me know, you know, where I need to be corrected here. And they didn't respond to either of these two letters indicating any interest in prosecuting the citations. And again, giving me the name of anybody there to communicate with on that specific matter.
Okay. I understand what you're saying.
Okay, so there's a failure there to indicate who that has a license has initiated prosecution on behalf of the people of the state of Hawaii, because Officer Davies is not licensed to do so, and they do not touch that in their opposition. So, you know, that's an issue with the invoking the jurisdiction of the court for the case. And again, the follow-up is the valid service of process, which is standard procedure across the U.S. And again, there's absolutely no comment whatsoever. And those are the two main points.
All right, I'll hear from the prosecutor.
Your Honor, the state would argue that the citation issued by Sergeant Davies in this matter does constitute a complaint and summons under Hawaii Statute 803-6, which does provide that a police officer may issue a citation in lieu of essentially in lieu of a written complaint. Right. As long as the citation contains certain information, such as the nature of the charge, the time that the charge will be initially heard.
I object to those.
No, you're out of turn. You're out of turn. This is not an evidentiary hearing.
I apologize.
I would just argue, Judge, that based on that rule, that the state did comply with notice requirements for Mr. Bickle. He did receive the two citations issued on the date of the offense and did sign those citations.
Okay. And anything further?
Those two pieces of evidence there were acquired unlawfully by Officer Davies when he conducted an unlawful seizure of my person and my property under the pretense of no license plates. And in the state of Hawaii, no license plates is a violation. It's not a crime. Now, the Section 803-5 for warrantless arrest, which gives him the authority to stop somebody if he believes that there's probable cause for a crime.
You see, but what we're here for today is a motion to dismiss based upon jurisdiction. We're not here on a motion to suppress evidence, because that's the motion that's before the court.
If he didn't have jurisdiction to pull me over, he didn't have jurisdiction to issue those citations, and those citations cannot be used to invoke.
Jurisdiction is used in a very, very different sense, quite frankly. Jurisdiction is the power or the authority of the court to exercise its power, okay? And
I would object.
Motion?
It has multiple meanings,
okay,
and I agree with that,
right,
but that's not the meaning that's being argued here. The meaning that I'm arguing has been laid out in law that the court has to have that power invoked. That's what we're dealing with, the invocation of that power. So I'm familiar with the fact that you have a scope of duties, and as long as you work within those duties, everything's fine. But those duties are only invoked by following the local process, which is what I'm arguing has not occurred.
Okay. I understand. I've read your motion in its entirety, and I've read the opposition, and I'm prepared to rule. All right? I'm ruling that the citations which were issued by the officer are summons for you to appear in court, and that is what starts the jurisdiction of the court to exercise its power against you. I'm not going to argue with you, okay? This is the findings of the court, okay? And that's what the findings of the court. And so we're properly before this court for 2 citations for no driver's license and no insurance. Now, if you have other motions to file, for example, motions to suppress evidence based upon an unlawful search and seizure, that's a separate motion.
I'm still going to object to this ruling because the officer is not a clerk of court, and only a clerk of court under Rule 9 of the Hawaii Revised Penal Procedure is permitted to issue a summons, and the form of a summons indicates clearly that the summons has to be signed by the clerk of court. He's not a clerk of court. He works in a different branch of government. He works under the executive. The clerk of court works under the judiciary, and that's a violation of the separation of powers to deem this that the state witness is also the state prosecutor and also the clerk issuing the alleged summons. And the notice had been filed in the court before it was given to me.
All right, that's the process that is filed in the state of Hawaii, is that when the summons is issued, that's sufficient summons for you to come to court. So I'm denying your motion to dismiss. If you want to appeal this ruling, you're perfectly welcome to do so. You have 30 days to file your notice of appeal. And if you file your notice of appeal, that will stay these proceedings pending that, unless you want to proceed to trial.
I'm going to appeal this. That's very clearly written out. I've already gone through this in California once.
Okay.
And I took 4 appearances before the judge agreed with me finally.
All right.
She needed an empty courtroom to do it, though. So I don't know how it goes.
I understand.
I do what I have to do. You do what you have to do.
I understand. Very good. Motion to dismiss is denied. Should we set this matter for trial?
I would object. I would like to enter a motion to suppress before.
Well, we can, if you want to file a motion to suppress, please do. But I'm going to set it for trial. If you set your motion to suppress, then that will stay the proceedings. And then if you file an appeal, that you can make a motion to stay these proceedings pending the appeal as well. I want to make sure that nobody loses anything in this. You too. All right. So we'll set a trial date. Let's Rule 48.
July 26th, Your Honor.
So we got to set a trial date before July 26th. And we can set a motion. If you file a motion, we'll set a date for the hearing on the motion. Or if you file your appeal, then we can stay these proceedings. You can make a motion to stay them pending the appeal. June 15th, 2016 at 2 p.m. for trial.
Could I ask, Your Honor, that we have the same date for the hearing on the motion and the trial?
That's
I'll object to that.
Okay.
All right, we can do the motion ahead of time, that's fine. Just ask for a separate hearing date on that. All right, if you file your motion to, your appeal, then we can make a motion, you can also make a motion to stay these proceedings pending the appeal. All right.
Good afternoon, Judicial Conduct.
Hi, this is Philip Bickle. I had sent a certified mail package to you with a complaint, and my tracking indicates that it was received. Now, I know you guys are busy, and you may not have already had a chance to go through what was in there, but I do have a set of ongoing cases with one particular judge who, I would appreciate it if there's any way you guys can get around to viewing this stuff as soon as possible, because I'm not a novice with law. I don't have a degree in law, but I have relatives in law. I used to be a brain imaging researcher. I have the competency to read law and understand it, and I've won cases as a defendant before where they were unlawfully brought. And in this case, that's what's going on. I've actually taken certified copies of the law from the Supreme Court Law Library and entered them into evidence, and the judge completely ignored the law and made decisions where he has no discretion, and I've laid that out in the motion to recuse that was included so that you guys could see all of that. And so my main concern here is I have chronic health issues, and that's one of the only reasons I read law. I'm stuck in bed a lot of the time, so it became a hobby to read that along with other scientific related things. And so when I put the time into collating the law and resources and entering this stuff onto the record so that it's clear I know what they're supposed to be doing too, and they completely ignore it, I've just put a lot of my own personal time into this, and it's fatiguing, it's taxing, and then it's also, as I say in the letter, it has a chilling effect on the public's perception of whether or not justice is actually being carried out, especially if somebody such as myself has put this sort of time into things and actually entered, like taken the procedures that they're supposed to be following and had the certified copies of those from state law clerks submitted into the record so that I'm making it clear I know what they're supposed to be doing. And they just ignore. In fact, the judge worked with the prosecutor, and the prosecutor, two of the prosecutors have committed crimes in front of him, and I didn't call them out initially on it because I was exhausted, and I would rather have that on paper, the issues that they did, which I'm working on right now to file issues against the prosecutors for professional misconduct. But I wanted to touch base with you all since I saw that the things have arrived, and just convey my urgency here, because again, everything that I wind up filing that's completely ignored because of bias is a waste of my time, and it expends my energy as somebody that's chronically ill, and it's all going up on YouTube. I have official copies of the videos that they make in those courtrooms. It's all going to go up on YouTube. I already have over 70,000 hits on my channel from years ago from a previous case, and I get many viewers every single day. And your office may start to hear from other people who have read what I filed, have looked at it, and have looked at how the judges carried himself and how the prosecutors have carried themselves. So they're not operating in a vacuum, and I just wanted to at least touch base with you all because, again, it's taxing as somebody that's physically ill to do the right thing and have somebody that's prejudiced against you just sit there and completely ignore the actual written law by the legislature and the higher courts. So then out of curiosity, what amount of time does it typically take for you all to investigate these sorts of complaints?
I have processed your submission, and it is going to the board. I'm staff, so it's not like I make the decisions.
Oh no, I understand that.
As far as time-wise, that I really can't say. But I'm glad I have you on the phone, because when I was going through your attachments, in your letter it says the mandatory judicial notices 1 through 6.
Yes.
I do have everything except for, I don't know if it's just stuck, but when I was going through it, I thought I was missing one of them.
I believe they...
Oh, no, I'm sorry. 4 and 5 were stuck together.
Yeah, the staples, they're a little sharp, and they kind of get intertwined.
Yeah, that's what happened. So, no, I'm sorry.
I was trying to make sure I had everything, believe me, because I was running on empty when I was trying to get this knocked out, and so you've got all of it. And see, those judicial notices are the certified, they're copies of the original, and the originals you can see where the state law clerk signed them, and that makes it a self-authenticating piece of evidence where nobody can even question whether or not that's legitimate, it's real, that clerk certified it, and that's part of the rules of evidence. But as far as turnaround, they don't have any sort of window that you might be able to comment on?
No, I don't.
Okay.
Don't.
And it's my understanding that this is staffed by 3 civilians and 2 lawyers.
There are actually 3 lawyers.
3 lawyers, and there are civilians involved, or no? What's the civilian count? Because that's a concern for me, because the issues that I raise are 4? Excellent. Okay, that's good.
Yeah.
All right, because I was concerned there, because the problem right now is that the prosecutor's a bar association member, the judge is also a member, and then any lawyers that will be reviewing this are also members. And the issues that I raise are actually systemic across the nation. I had the same sort of thing come up in California, and the case was finally dropped there. The judge made up whatever reason she needed to and dropped it. But it's systemic, and it actually made the LA Times back in the early 90s. And it's been swept under the rug because there's hundreds of millions of dollars involved in unlawfully acquired money by this abusive process that's going on between the judges and prosecution. And I am not dropping the issue, so here I am. But I'll wait to hear back from you guys. I presume you guys do make a contact later with complainants, or no?
Yes.
Okay. All right. Well, I guess I've said all I need to say. Is there anything else I should maybe be made aware of for this process?
No, not at this moment. Your current address is what's listed, the P.O. Box 792.
That is correct.
Okay.
And I will have one other complaint against the initial judge in the case, who should have dismissed it right away, who acknowledged that he didn't even have a complaint before him to charge me with, but he wouldn't let the case go. So I will be sending that over to you guys as soon as I'm able to. But thank you for your time.
So,
oh, I'm sorry.
Point of clarification. The other one you're going to send is, this is against Judge Udovic? So the other one you're going to send is on a separate judge? It
is, because that other judge, Judge Freitas, he was the very first judge I came before, and I actually have him on the official transcript openly acknowledging he did not have a complaint before him, and they're required to have that before they can ask for a plea. So I'm going to put that together. Again, I have chronic health issues. I run out of steam easily, and I can see them taking advantage of this, but that'll be sent your way as soon as I can get it out, and I appreciate your time for listening to me and communicating with me.
Okay. All right. Take care.
All right. Bye.
Bye.
Hey, Charlotte County. This is Charlotte County COPWATCH, and I wanted to explain what fair use is. You can use pieces of news articles if you're doing it for news reporting, you have commentary, and you're doing it for education purposes. So that's what fair use is, as you can see right here. Another reason why I wanted to make this video is to let you know I have just joined with Patreon. A nice thing with Patreon, I make no money on YouTube. They took the money away years ago. And so this is another way to give, and it's a nice thing too, because you can give monthly. You can give $1, $5, $10, whatever. I do 4 to 5 hours a day on trying to wake the sheeple up on how corrupt it is and different ways that you can fight the corruption. So Patreon is a way that you can do it, and then of course the old way is still there. Donate to Charlotte County COPWATCH with PayPal or credit card. So keep that in mind. 4 to 5 hours a day. I make no money, but the corruption happened to me, and I'm sick of it, so I'm trying to wake people up. But my wife would love it if if we could get some help out there. There's 47,000 subscribers. Just think if each one of you subscribers just gave let's say actually, yes, $1 a month. 47,000 subscribers gave $1 a month. That would be awesome. That's not going to happen. But anyways, that would be great if it did happen. But do the math in your head. Just think about it. Like I said, 4 to 5 hours a day. I get no money from YouTube. YouTube has gone nuts. You can't do anything anymore. They're taking the money away everywhere. So these are a couple different ways that you can still help out with all this time that I put in. And as you know, I'm in a special situation where, at least I can do it, 4 to 5 hours a day. We have a cleaning company during the day. That's what allows me to do this, and we're debt-free. So this is my hobby. I don't go fishing and all that other crap. I try to save the world. So help me out to make the wife happy, man. In fact, if you guys did give $1 a day, and there was 47,000 of you, and you did it, and each of you gave $1, and that was every month, oh my God, yes, I could quit. I could start suing them. Another idea, too, that we have is, if I got, some funds, we could actually contact everyone that has been ticketed and or arrested and put in jail and start sending them postcards to let them know we're here, and to see if everything went all right, and if it didn't, find out their story. So we could even do more investigations and more lawsuits. Lawsuits take money. So just think about that. 47,000 of you so far right now. $1 a day. $1 a month on Patreon, or $5 a month Patreon, 10, 20, whatever. Just do the math in your head. Help out. This is a lot of work every single day. Thanks.